Right, good afternoon everybody. Thank you for coming. This is the first time I think that we've hosted a webinar both in person and virtually. It seemed like overkill up until Friday when we got an announcement, and Sunday we got another case that we had to look after, so we're probably glad that we did. For those that are in the room, quick health and safety. For those that are online, maybe just don't sit too close to the screen. There are toilets located in the stairwells out there. You'll need an access card to get back in, so there is one left on the table just outside the door if you need to use that. Ladies are in the stairwell to the left, gents to the right. In the event of an emergency and alarm will sound, please exit via the nearest stairwell as soon as possible and follow the instructions of fire wardens. I'm sure you've seen them before, there'll be some fluoro involved. And there's an assembly area behind the building on Chancery Street. I'm told I don't need to give you a caution about earthquakes because we're in Auckland, yeah, that's probably the end of it. Now, thank you all for coming. We've got a mix of people I know, people we don't know, and people that are online that Grant and I can't see who you are. So I'm going to assume there's a mix of criminal and competition people here. So we're going to try and speak today to address both the audiences that might come in. So there might be people that know a bit more about criminal law and a bit less about competition law, and vice versa. And there'll be some that obviously know about both. My name is Ben Hamlin. I'm the Deputy General Counsel for the Commission in the competition area. Beside me is Grant, who's currently Trade Cartel Manager as a Excellent. And we have a third panellist who, for technical reasons, can't join us right now. That's Charlotte Brook, the team leader criminal at Crown Law. She will join us once we're at the end of the slides and will come up on the screen. Unfortunately, we'll have to run through all the slides without the benefit of her wisdom. If there's anything that she wants to add, we'll give her an opportunity to do that then. So if we could turn to the first slide. Why are we here today? At a really blunt level, we're here to talk about this policy that the Commission has put out in draft to facilitate better submissions and to receive your feedback and to answer any questions that you might have that we're capable of answering. But I think there's other reasons why we're here. Standing back, one of the reasons we're here is that criminalisation of cartel conduct will kick into force in April 2021. Those of you that were around when the first MB paper came out in about 2009, it might seem like this has been coming for a very, very long time, but it's starting to feel, I think, for most practitioners like something a bit more real and on the horizon. But then stepping back one step further, the reason that we're actually here is that cartels cause significant harm, and that around the world that's recognised, and leniency policies are recognised as one of the most effective tools for destabilising cartels, ending them, and in that way benefiting the wider public. So it's really great to have you all here, both to hear what we have to say, to provide us feedback, and we are very genuinely keen to learn from you and to understand what improvements we can make to our policy. We'll try and answer questions as best we can, but with something as complex as this, there may be questions that we or Charlotte can't just answer off the cuff. So feel free to come and see us afterwards. Charlotte will have to get on a plane and we'll see what we can do. But even just having these questions, that shows us the areas that we may need to do a bit of work to expand on the guidelines or where we should focus our efforts as we move to a final. So if we can move to the first one. Excellent. So there's two kinds of changes that we're going to cover. I think the majority of the time will be spent on the first, which is changes to reflect cartel criminalisation. But there are also some changes to the policy that are more in the nature of updates to reflect changes in international practice and also our own practice, or the things that have arisen since we last updated the policy. So I think before we go straight into the changes, we'll get some context. Firstly, because for some people it's new, and secondly, for some people they've forgotten virtually everything that they learned over summer, including the date of the seminar. If you're out there, the practitioner that joined yesterday and wondered why it wasn't working well, thank you very much. Your dedication is very much appreciated. So we won't focus on the prohibition, But for those that aren't familiar, you can't enter or give effect to an agreement that contains a cartel provision. And a cartel provision is one that has the purpose and effect of controlling prices, controlling output, or allocating markets. The Commission has had a leniency policy since 2004. It's made updates to it in 2010 and 2018. So in some respects, the updates that we're going to make in 2021 are just another evolutionary step. And I can almost guarantee they won't be the last changes that we make to the policy. Now, the new criminal offence that comes in brings with it a 7-year jail sentence as a maximum, and immunity moves to immunity is something that can only be granted by the Solicitor General. I'm just seeing some concerned looks. I'm wondering if there's something with the sound. So only the Solicitor General can grant immunity, but the existing civil prohibition will remain, and the Commission will be able to grant leniency in respect of civil penalty proceedings. So if we move on to the next slide. So at one level there will be a dual track procedure, but I think at the outset it's important to bear in mind that leniency and immunity don't conflict with each other. They both have at their heart the same objective, which is to bring forward, to essentially further the public interest by bringing forward valuable evidence that wouldn't otherwise be obtained, and in that way disrupting cartel conduct. So Francis, will you take over?
So I think probably the starting point is there is change, but the same way of going around getting leniency will stay the same. The application process will be the same. We will be the people that manage the process of leniency. Then if we make a recommendation, after we've considered things, we'll make a recommendation to the Solicitor General. That will then be assessed. But the important point to think about is what are the changes for you as practitioners in terms of coming into the program? They're still the same. There's going to be some different considerations in respect to criminal immunity and whether we make that recommendation. But as we were talking about yesterday, the same way of going into the program is there. Overseas, sometimes there's different things that go on. You have to go directly to a public prosecutor to get immunity. But we've worked out with Crown Law, everything will still go through us and we will manage the process. We think that's quite important because obviously we've worked with many of you that are sitting in this room and hopefully the people that are online. It's quite important that continuity to understand how that system will work. But there is also a learning process for us in some of this, to be fair, from the Commission side. I think that's probably a fair thing. We have to work through with Crown Law on a number of things as we're going through the processes. Importantly, only the Solicitor General can grant immunity. You might want to say all sorts of things to us about why it's worthy of criminal immunity, but ultimately it will depend on the recommendation and then as to whether they support the recommendations. It's not our call. Overseas, some agencies do have the ability to do that. New Zealand doesn't. Let's just be clear about that. It's free. We were talking to our DOJ colleagues last year. There are some benefits of a one-house approach, and there are some real benefits of the independent look at this as well, in terms of the Crown Law and Solicitor General reviewing it. So I think that's quite an important thing, is there will be consistency. But in terms of leniency from civil proceedings, I know a number of people here have made applications. I think probably exactly the same criteria will apply. I don't think there's going to be any difference. The only change will be around Type B. Type B, we say there, Type A, the Commission is unaware of the conduct. So that's examples where people come forward, just call the General Manager and say, hey, we've done due diligence, we've done a move, we've done whatever it is, we've uncovered something. Or I know Andy and the international ones, they give you a call and they come in. So we're completely unaware of the conduct, we've got no hint of it. Type B is we don't have sufficient evidence to prosecute and the applicant can provide valuable evidence. And importantly, to be consistent with the criminal approach we'll talk about later, we're also saying as part of that proposed change, Type B, even for leniency, there must not be reasonable other avenues to obtain that information. So the Type B can happen when an investigation has happened, and I know a number of people have used it. Importantly, to give consistency between civil and criminal, we are placing that element on there, that there can't be reasonable other avenues to obtain that evidence. The other criteria pretty much are exactly the same. We have tried to, I think, a number of people in this room, when we've gone through the criteria for leniency, have raised points with us about clarifying points of those conditions. We've tried to do that, but if people do think anything is still unclear under those criteria, they're the same ones that have been there since about 2009. So happy to take any feedback on those, but they generally are the exact same ones. Not have coerced others. I've had some quite lengthy debates with practitioners about what does coercion mean. We are really talking about people that economically coerce people, so people that force them essentially with very strong threats. Coercion is quite a strong threshold for us.
I think we'd take physical coercion if it was there, but we're not.
We don't generally ever see that. I don't think I've ever seen it. Then over to you, immunity from criminal prosecution.
Great. So many of you will be familiar with the Solicitor General's prosecution guidelines because they have a really useful chapter on the decision to prosecute, and they're applied throughout New Zealand by agencies, whether it's in a health and safety case, a tax case, the Commerce Commission in its criminal proceedings, or in the police in making their charging decisions, or the Crown Solicitors continuing those decisions or otherwise. So it's quite a useful document. It's been around for a number of years. The current edition is from 2013. I understand that there may be a new version in the next year or two. We'll just have to see. Charlotte's better placed than us to talk about that. But one of the sections in there, Chapter 12, covers immunity from prosecution. It's described as a power that the Solicitor General uses sparingly. And it's for cases where it's clear that prosecution would fail or be significantly weakened if it wasn't available. We won't go through it in detail, but it's available on the Crown Law Office's website, and paragraph 12.7 in particular sets out the matters that the Solicitor General will generally need to be satisfied of before it will grant, or he or she will grant immunity. And the most important ones, I think, for us, or most relevant to us, are that the offending must be serious. The evidence offered must significantly strengthen the prosecution case and be unavailable elsewhere, and the person seeking immunity must not be more culpable than the remaining defendants. If you want to move to the next slide. However, the Solicitor General, and I should say several Solicitor Generals, because the work that's been done with the Crown Law Office picks up on work that was done starting back as far as 2010. Probably actually started earlier, but certainly there was some material published back then. And the Solicitor General recognises the benefits of the leniency program, the importance of it to the Commission, the first in nature of it, which is somewhat different from the way that immunity is granted in relation to other offending. And the Solicitor General also recognises that the principles and the guidelines will need to be applied with a degree of flexibility to reflect the different nature of cartel offending. And I think general criminal offending is particularly serious criminal offending. It's usually personal. Cartel offending, generally speaking, is corporate. It is generally speaking, leniency happens at the beginning of an investigation. It may well be, in Type A cases, the start of the investigation, the cause of it. Immunity more generally in the criminal law is often late in an investigation or during the prosecution itself. So there are some differences that have to be reflected. And the currently in draft, the Crown Law Office has published guidelines on immunity from prosecution for cartel offences. We've put that on our website in parallel so that you can comment on the Commission's policy, knowing what Crown Law says. If there are comments you wish to make about that guideline, you can direct those to us, but ultimately we'll work with the Crown Law Office closely, but the Solicitor General ultimately makes decisions on those things. And now that we move into that criminal area and recognising the seriousness of moving into the criminal area, we will accept the decision of the Solicitor General on what those guidelines are to say. I am hopeful that those guidelines, however, provide a high degree of clarity about how the Solicitor General is going to apply the more general principles in the Solicitor General's guidelines to the specifics of cartel offending. And I draw your attention to paragraphs 13 to 19, which if you read the general guidelines and have a lot of questions, paragraphs 13 to 19 of the guidelines on immunity for prosecution of cartel offences might answer a lot of those questions. Lastly, the fact that there is something specific to cartels doesn't derogate away in any sense from the Solicitor General's more general power to grant immunity from prosecution, but the reality is it's likely to be quite rare that there's an application dealt with in that way when the Commission has a policy. Probably one of the most issues that will interest you the most, having heard from Grant that the test for leniency hasn't changed a lot, is when is the Commission then going to recommend to the Solicitor General that immunity be sought? And Grant will go through the specifics more generally in a second, but we've set out in paragraph 66 of the draft, and we've highlighted that because it's important for you to get familiar with that, and if there are problems with that, to tell us. That the Commission will make a recommendation when those criteria are met. We will appreciate the importance of certainty, both to practitioners and to firms in the market generally, and also to the operation of the leniency policy specifically. And so we've tried to make that as clear as we can, but we really appreciate your feedback on that. Those criteria are intended to reflect the guidance from the Solicitor General in the form of the various guidelines that have been published, so that as much as possible, the two systems are aligned. A question that we saw in an article published was, well, what would happen if leniency was granted and immunity was not? Well, the starting point is to try and ensure that the policies work as well as possible, so that that is a circumstance that arises rarely, if ever. Now, an important point though to make is that the recommendation, it can be made at the time that leniency is sought. But if you look at those criteria, and one example is the Commission going to investigate the matter that's going to refer to it? The Commission can also make a recommendation to the Solicitor General at a later time if the criteria were now met. So if the Commission, for example, had picked up a case that it initially had not thought it was going to look at, or if it gained new information and it now appeared that there was a prospect of a criminal prosecution, then there's the opportunity to refer that matter on. So it's not necessarily a one-shot game. We're not trying to snooker anybody. So with that, Grant, if you want to move on, and you're going to take over from here.
Just one very quick point though. One of the things that is important just to mention in terms of, we've tried to create a system whereby many of the same factors that appear in our leniency we've sort of met quite clearly with solicitors' guidelines. So when we're talking about seriousness, and for example, the conduct will be investigated, generally with cartel conduct, if you take both that aspect of seriousness, it not only makes us probably more likely to make an immunity recommendation, but it also means we're more likely to investigate. So some of these things actually work on both elements, both our leniency investigation, our cartel investigation of leniency, and also the recommendation. So there's actually an area where essentially we're answering the same criteria. So you're not going to have a whole different raft of criteria having to think about. Most of them, pretty much if you have the material in front of you from the client, you would think that you would be going through the process and we would be thinking about whether to recommend criminal immunity. One of the questions someone did ask me here before Christmas was, will you recommend immunity in every instance? I think the fact that we're setting these criteria out does not mean in every instance we will, but I think the reality is and that is the case overseas. I'm talking to a number of agencies, they don't necessarily recommend every single civil leniency case for criminal immunity. So that is something that we will need to work through. If people think that is an automatic assumption, it will not be, but I think many of the same criteria are relevant to both factors. But when we're thinking about whether to recommend immunity, obviously we talked about those criteria for leniency, they all have to be met. We're not, if one of those is missing, just assume you're probably not going to get leniency and you're not going to get a recommendation for criminal immunity. When we say the conduct will be investigated, it's important if you think about it this way, the less serious matters may well potentially get some sort of leniency assessment, but they may just not be prioritised for further investigation. So there may be examples where leniency is granted, and we can think about ones where there are international matters and there's a tiny little piece of conduct in New Zealand. We may not prioritise that for further investigation. That may mean we do not prioritise it for criminal immunity. That is consistent with the overseas approaches, which we think is a sensible approach, because if there is de minimis, everyone has finite resources, we're not necessarily going to go after every single investigation. When we say a prospect that criminal proceedings may be brought, we're not sitting there with a crystal ball being able to say exactly what the charges will be at the end of the investigation. But I think that the idea is that there is a real prospect that a party at the end of this, once we know the full set of facts, could face criminal prosecution. That doesn't mean we have to be absolutely certain. I'm going to talk again about this before Christmas. I don't think we have to be in a position that we have to be certain. People assume that because we get a leniency application now, we automatically go through and we take action against people. We don't. But I think there needs to be a real chance of that. Would you think that's a fair?
Yeah, I don't think that's intended to be a high threshold.
No.
It is simply that there is a prospect. If there is no prospect of a criminal prosecution being brought, then it would be a waste of the Solicitor General's time for us to refer it. And frankly, the Solicitor General might not find that this immunity was likely to assist a subsequent prosecution because there wasn't going to be one. So, but equally, we're not expecting that people will spend a lot of time saying, look, is this a mad, or what are the chances of prosecution? If there's a prospect of a criminal proceeding, then it would, you'd meet that criteria. I think that last criteria, the evidence being valuable. One thing I'd just like to highlight is para 16.2 of the Solicitor General's guidelines on immunity for prosecution for cartel offences, where the Solicitor General has indicated that it will generally follow that where the Commission was not aware of the matter before the application came forward, it follows as a matter of course that the applicant's evidence is going to significantly strengthen any potential prosecution and couldn't be obtained elsewhere. So in the type A case, I would expect that criteria will be met relatively swiftly, provided you've met the threshold to have leniency granted. Charlotte, who will be listening to this right now, can feel free to comment if she has anything she wanted to say more on that point.
I think it's important, just from what Ben said as well, the actual guidelines themselves do quite clearly recognise that you may not necessarily know at the time of the application whether it will result in prosecution. But I think it's probably more the question, is it capable of a prosecution as opposed to whether it definitely is or definitely not. I think the other thing that's important as well, type A applications, it is acknowledged that, as Ben said, we're going to be in a situation where you don't know about it, therefore you couldn't have a reasonable avenue to go and get that information. That's the reality. I think probably where the most significant change for us, as I mentioned before, is around type B. They are changing. That is important to acknowledge. It has been increased to type B for both leniency and for criminal immunity. It will, I think, there is a degree that leniency will be slightly harder to obtain, and in a type B scenario, we can't reasonably obtain that information elsewhere. Does that mean in a situation, for example, we have an international matter where the information is held offshore, we can't get at it? So in that sort of scenario, I don't think it could be said that you could reasonably obtain it elsewhere. Some people might argue you go through one of the mutual assistance agreements or something like that, but I think that's probably stretching it a little bit too far. I think probably where we need to think about it is probably in the instance where we've started an investigation and someone says, actually, I'm going to make an application before I respond to my Section 98. I think we need to carefully work through that, because that's probably the sort of situation I can imagine where we're going to need to think about what does the actual reasonably obtained elsewhere mean. But the essence is, though, with a type B application, and this is something that I must admit I know a number of people in this room know, it's still better to make that application, because if we do not actually grant you leniency, we cannot use that information. So there's still always benefit in actually making that application. And that's one of the things I know a number of these people, well, we can't use it against you, we can't use it. So I don't know, John, that's
my concern is it's going to discourage making the applications.
I think we acknowledge that making leniency harder, which this will, in a specific type of case, there might be a few applications that don't come in. On the other hand, I think that what this would highlight is the benefit in getting in first and getting in early. The earlier that you get in the investigation, the more likely it is that you are providing the kind of assistance that the Solicitor General will find justifies the grant of immunity.
But by its nature, moving from an objective test to a subjective test, you've got, at the moment, it's whether there's sufficient evidence to issue a proceeding. That's fairly objective. Whereas if you're leaving yourself open to a commission decision, well, is it valuable evidence that can't otherwise be obtained elsewhere? Well, that's quite a subjective test. You'll be thinking to yourself, well, I don't really know what the commission will decide on that, so I might be more reluctant to make an application.
In order to make sure that people online can hear, but what was being raised as to whether this test it incorporates a degree of subjective assessment that, as opposed to the previous test, which might be more objective, and therefore it might discourage leniency applications. I think the key point is probably that is a really interesting and useful point. And if you, a written submission on that would be really useful, so that we can fully understand that. I think that it's probably not the place for instinctive responses, but I do think that we have to recognise that when we move into the criminal jurisdiction, we are not able to completely rewrite the criminal law that sits there. It is a very serious matter to grant someone immunity from a serious criminal offence, and so what we don't want in particular is to have something that appears certain but in actual fact hides an issue that then crops up when you actually come to apply it. So we want people to know, well, this is the test that you're going to have to meet in front of us and in front of the Solicitor General. So I don't know if you have anything more you want to add, or whether that's...
I think, yeah, but we're aware of that. We're going to try and work with and be interested to see what people submit on that. But I think the reality is I think the threshold, as I understand it when I talk to other agencies and also the criminal bar, they would expect something like that. It's not to be a shortcut for investigation speed that you offer immunity from prosecution. If it's an investigation is underway, the earlier the better. But my point was, even with the type B scenario, it still makes sense to apply, because if we ultimately don't use that information, if we can't use it against the client. So I've always been quite curious. We can't use that as evidence against your client, and that's still going to be the same situation, as I understand it, under the draft policy, and that's quite an important point. I think even with the type B, I know some people in this room do use type B and are aware of that, so they take advantage of that. It's just an important thing to be aware of. Outside of leniency, there is obviously cooperation. Cooperation will still be there. It will be available for civil and criminal. I think importantly, and this is where we need to come back to the fact that outside of our policy, we will still retain, as the agency taking the prosecution through a panel, but we will be the people that have an enforcement discretion, who can actually make those decisions around enforcement. So when we look at cooperation, it will be us through the public prosecutor who will make those decisions around what cooperation discounts, and those still are there, the same ones will still be there. It will be possible to get 100% cooperation. They are there at the moment. So I think that's an important point to remember. I thought we'd talk quickly about some other key changes. Over the years, and this is probably more, people have picked this up as sort of a bugbear between the policy and the agreements, and the draft agreement was, is 27 covered or not? We think explicitly now we're at the point where we're not going to cover section 27. they're not covered by the policy. I think that's particularly important for us in terms of gauging some of the things around seriousness and those sort of things when people want to put forward an application for immunity, their client a recommendation. I think it's quite important that we clarify that 27 is not covered. Individuals, I think in fairness, there has probably in the last sort of 3 or 4 years, probably sort of a year before the last series of changes, there was more of a focus on individuals. I know a number of practitioners would have got more used to us interviewing people in marker phases and those sort of things. There's been a real push, I think, to engage more with individuals, even within a corporate application. That's something we really value, to be fair. As the person who oversees the program, I can tell you, we really value that individual's evidence. Not just because obviously we get the proffers and those sort of things. Anyone that's in criminal, does criminal law doesn't, proffers is named for just basically the statement that comes forward from the corporate applicant. But importantly, individuals, we thought about the situations where they have leniency, for example, but they have other valuable information. Can it go further than just what necessarily the corporate has? The individual gets what's called derived corporate immunity, DCI, but we've made a conscious choice that leniency for individuals can go wider. So let's say, for example, they're at one business and they've been engaged in the same sort of conduct or something else at another employer. It can actually cover that wider ambit of the conduct for them, because it can be particularly difficult for individuals to try and go, I'm covered for some of this, I'm not for that, how do I engage, how do I not engage? So there is that real potential there. We think that is really trying to help the individuals and be able to manage some of the situations, particularly when they're going to need to have independent legal advice as well. We think that's where it should hopefully help. The reason why we say they're required to certify they've made reasonable efforts to comply with leniency, I think in fairness, it's not saying disrespect, sometimes individuals have been absolutely amazing as witnesses. Sometimes they haven't, and sometimes they popped up with things right at the end of investigations. I think this is an idea of basically you understand what you signed up to at the beginning, and we may come back and check on that to make sure that they certify they've done the necessary things that they need to do to comply with it. Ben, over to you for the next step.
So one of the immediate next steps is we're going to try and get Charlotte connected. So the submissions on the draft close 5 PM on the 10th of February, so perfect waiting day work if you're looking for something to do over the long weekend. And obviously we intend to publish a final leniency policy before the cartel criminalisation comes into effect in April 2021. But I think an important point that is the last one down the bottom, we will continue to review the efficacy of the leniency policy, and if there are changes that need to be made, then those changes will be made. So it is something that we acknowledge may need to move over time. I think the Crown Law Office will also be looking at its practice, and we'll see how that may need to move over time. So yeah, if you're looking for the documents that we've referred to today, they're available on the Commission's website. I think that you are probably here because of an email, and there should be links in that email. But otherwise, if you go into the news feed, you can see it just before Christmas. There was a publication in there. So there's a copy both of the Cartel Leniency Policy and Guidelines, and also the Solicitor General's draft guidelines on immunity from prosecution. So
that's what my James. It's not Charlotte.
Charlotte, hopefully if everything went well, you were able to hear the discussion that we had. And I must say that's looking much better picture quality than when we did the test. So I'm very glad about that. I'm not sure, Charlotte, whether you had comments that you wanted to make before we started. Otherwise, we can throw it open to questions either from online or from the floor.
Yeah, I did actually make some notes while you guys were talking, because we had anticipated that you'd be able to throw to me during your presentation. So having said that, I didn't want to speak at this point. I've just got a few things that I thought I might be able to clarify or help with before we get to the questions. Firstly, we've been saying over and over that only the Solicitor General can grant immunity. In practice, it's actually the Deputy Solicitor General Criminal who grants or refuses immunity, and that's pursuant to delegations. I was acting in the Deputy Solicitor General role for 7 months, ending yesterday when our new Deputy Solicitor General took office. So I've got experience in both granting and refusing immunity requests. And I've been at Crown Law for over 10 years and have been involved in a large number of immunity applications, as well as helping the Commerce Commission with drafting these guidelines over the past year or so. So I do know a little bit about it, but I thought I should clarify who actually does it in terms of the personnel within Crown Law. And also just to be clear that the process for granting immunity in these cartel cases is exactly the same as we adopt for the police and other enforcement agencies. So it's always the case that enforcement agencies make an application to us for immunity, which we then either agree to or not. So it's always the case that the police, for example, can't guarantee immunity to people who might be seeking it. I thought it also might be helpful to explain the process by which we actually deal with those applications in the office. So when we get a request, it will be assigned to 2 different counsel within our team, usually one more junior than the other. The more junior team member will prepare what we call a first opinion, which is essentially a recommendation for the Deputy Solicitor General outlining factual background, the reasons why immunity is sought, whether or not it matches the criteria or meets the criteria in the guidelines, and making a recommendation. The more senior team member will then prepare what is imaginatively called a second opinion, which is not a peer review of the first opinion as such. It's actually an independent opinion, but without having to go again through all of the factual background and indicate whether or not they agree or disagree with that recommendation. And then both of those opinions are given to the Deputy Solicitor General. It's not uncommon for the first and second opinions to disagree. It's not uncommon for them to agree, but for the Deputy Solicitor General to reach a different view. The idea is that we thoroughly test all of the criteria and applicable factors before a decision is finally made. In terms of timeframes for processing these requests, we had been asked if we could commit to a timeframe for turning them around, and we just didn't feel comfortable doing that. It's like asking how long a piece of string is. We typically suggest a working window of about 4 weeks for any piece of advice or law officer request that we receive. We can turn things around much more quickly. It's not uncommon for us to receive requests in other contexts, in the middle of a trial, for example, and we can turn things around in a day if we need to. But larger files will obviously take a while, and it's not uncommon for us to have questions once we've received a request and reviewed the file that we might then need to go back to the enforcement agency to either answer themselves, or in the context of immunity, might need to go to the person or the party seeking immunity to get some further inquiries answered. It's going to take some time for us to build some capability in respect of cartel offending. Obviously, this is new territory for everybody. So while we've got lots of experience in granting immunity requests, we don't have any expertise in respect of cartel offending. So when it comes to things like evidential sufficiency and the seriousness of the offence, we're going to be relying heavily on advice from the Commerce Commission and any other material they provide us. So if it's a matter where parties have provided submissions to the Commerce Commission, we would expect those to be passed on to us to review as well. In terms of seriousness specifically, it's something that's been touched on. As I say, we'll be guided by the Commerce Commission as to how serious a particular cartel offence is of its kind. I would have thought that most cartel offending, if it reaches the point of being prosecution, will satisfy that seriousness criterion. In terms of the reasons why we sometimes reject requests for immunity, and it does happen from time to time, it's almost invariably because it's clear that the prosecution can proceed without the evidence that immunity would make available, and it's just a case of making an already decent case more strong. And that's not a good enough reason for granting immunity. So again, it's really an exhortation to go for type A immunity, where that's not going to be effective. It's always going to be the case that you're offering evidence that will make prosecution possible when it would not otherwise have been. So that's, if people are wondering what are the barriers to immunity, that's almost always it, when somebody at the end of the investigation suddenly wants to give evidence and be immunised, but in fact the prosecution is already good to go. That's not a situation in which immunity will be granted. I wouldn't completely rule out the case where we have granted immunity sometimes in cases where there is a prosecution case, but the witness to be immunised offers evidence that actually reveals that their getting is much more serious than was previously known, or perhaps reveals other offending. But in general, if we can proceed without the immunised witness, then immunity won't be granted. Another point I just thought I'd mention is the guidelines make clear that there is also the possibility of parties seeking immunity directly from the Solicitor General if, for example, the Commerce Commission has declined to make a recommendation. And yes, that is a theoretical possibility, but I just want to be clear that if we were to ever receive a request directly from a party who had committed an offence, we would always notify the enforcement agency concerned and seek their views about it. So you wouldn't be able to pursue immunity confidentially. The reason for that is quite clear from the Solicitor General's prosecution guidelines, which say, if you've got them in front of you, it's at 12.5, that the only purpose of giving immunity is to allow the prosecutor to use otherwise unavailable evidence. So if it's a situation where the prosecutor has decided they don't want to seek immunity because they don't need this witness's evidence or they don't want it, then that's not a situation in which immunity would be appropriate. So yes, you can theoretically apply to us directly, but that will mean that we will be consulting with the Commission. And frankly, it's difficult to envisage a scenario in which we would grant immunity over the Commerce Commission's objections. That's not to say the prosecution is inevitable if immunity is not granted. Of course, there will still be prosecutorial discretion and the ability of the Commerce Commission to decide simply not to prosecute a particular party, perhaps taking into account any cooperation that they might have offered. I thought I'd also just clarify that we are happy to receive feedback about the draft guidelines that we've published about granting immunity in cartel cases. It's probably most efficient to just pass all your feedback, whether it's about the Commerce Commission guidelines or the Crown Law guidelines, to the Commerce Commission for them to collate, and we'll be working closely with them on any amendments that are proposed to be made following the closing of the consultation period. And then just finally, I think Ben mentioned that there is a review proposed of the Solicitor General's prosecution guidelines. That is true. We'll be doing a pretty much a complete overhaul, which is we envisage taking about 2 years, commencing in the 2021-2022 financial year. I don't envisage that there will be any substantive changes to the immunity clauses. However, it's a much higher level review than that. It's likely that the language will change just simply to make it plain in English. And perhaps even incorporate some Te Reo Māori as well, but I don't imagine that anything will change in relation to the criteria for immunity. Obviously, in the new edition, we will probably make reference to the cartel guidelines. It's possible we might actually incorporate them into the main prosecution guidelines, but the cartel guidelines are so lengthy that we'll probably keep them as a standalone document. Right, that's all the comments that I thought of then while you guys were talking. I'm happy to answer any questions that anybody might have.
So thank you very much for that. We have the potential for questions to come electronically, or we can have questions from the floor. If we get questions from the floor, we're going to have to repeat them back so that we can make sure that people online can hear them. So I'd encourage you to keep your question length to shorter rather than longer. If anyone wants to make a statement, then there's a written submission process.
And they can do my dance.
So I'm just looking to the back as to whether there are any questions from the people online that they want to hand over to us. No, I don't know if that's good or bad, but is there anyone in the audience that has a question?
Just a question in terms of if you're going through a paperless process and you're getting the undertaking from the Solicitor General, would there be is that possible to get that done paperlessly.
So the question there is, if you have a paperless process, how do you get the undertaking from the Solicitor General in a paperless way? I'll hand that over to Grant and Charlotte.
When we had the previous discussion, and I hope I'm not wrong, we can do it in a paperless way. We would get the letter and then we'd read it out to you. It would be the same process. Charlotte, so where we have a paperless process where people...
Yeah, maybe your definition of paperless is like, we're largely paperless in Crown Law in the sense that we do everything electronically. So we would just send in a PDF of the undertaking from the Solicitor General to the Commerce Commission, and it would be up to them to communicate it to the party who has been announced in whatever way they think is appropriate. So you could visit the office and see it, or you could have it read out to you on the phone.
The other question relates to the independent advice for the individuals. That's the Solicitor General process, but not the Commission process. Is that right?
Okay, so the follow-up question is the requirement for independent legal advice for individuals, is that a requirement only for immunity or for the Commission's process as well? I think practically it would be highly inefficient to have people instructed, represented jointly for the purposes of leniency and then to move to individual representation for immunity only. So I would encourage people to start with individual representation from day one if there's any prospect of it going down the criminal path. However, the Commission is not insisting on that in the current draft.
Yeah, because there is obviously a tension there between getting the information and getting in a timely way, particularly if an individual needs employment and competition advice, and just a timing sort of issue there.
So the point that was made there was that there's a tension there between the timing of getting your leniency application in and getting individuals represented. I think that's a completely valid point. I think and you may wish to make a point in submission on that. That said, I think the question of whether the point where someone needs legal advice may not necessarily be right at the start. The independent legal advice might be when they're understanding the obligations that they are signing up to, as opposed to perhaps right from the very first moment. I'm not sure, Charlotte, if you have anything you want to say on that point.
Yeah, I mean, I'm assuming that people in this situation or organisations in this situation will be represented. That requirement for independent legal advice was very much targeted at the situation where people have been prosecuted by the police for murder or drugs or whatever, come to the police seeking immunity confidentially. They don't really want their own lawyers to know, that's not uncommon. And we usually facilitate some sort of independent legal advice from them. I don't really see that as being as much of a tension in this particular context. The point is that the person must have legal advice. And I'm imagining that there might be sort of scenarios where it is likely that one lawyer is going to be representing multiple parties in a cartel. If so, then yes, they will need individual representation at some point, won't they?
Thanks, that's pretty useful. Right. Are there any other questions from the audience? And I'm just checking again that there aren't any questions from the virtual audience. I feel like I should be an auctioneer and going once, going twice. Right, you can all go back to lunch. Look, thank you very much. If we haven't got any more questions, we'll close it there, although obviously we'll be still in the building. Do we have another question?
I did. I don't want to monopolise them all. It was just about the Genuinely Corporate Act, and I apologise if I've missed something and reading through stuff on Christmas break, all of those things. Just wanting to clarify the genuinely corporate versus the isolated acts of the individuals.
So the question there is whether this seeking of immunity, what do we mean when we say the seeking of immunity has to be a genuinely corporate act? So Grant, I'll pass that up to you because you've got more experience on it.
I think, Ali, in my experience, it's generally been ones where it's a genuine corporate act. One, the corporate is not trying to say this is just the individual, they were doing this in private fancy by themselves, it was nothing to do with us. I think the flip side as well is there was one about 9 years ago where an individual was also involved in some other aspects of crime that they were involved in, so it was nothing to do with the culprit. It's got to be, when we say genuine corporate act, it's got to be conducted through the business. It's everything to do with the business. It's not like let's say, for example, they were talking about selling Ferraris and they work for a photography company. In that sense, it's got to be the corporate link, the business that's going on. It's not a particularly difficult criteria for people to meet. Sometimes it can end up in a scrap in the employment situation as to what the culprit, whether they were sanctioned to do it, whether they weren't sanctioned to do it. But I think for our purposes, when we ask people to do that, it's almost like proving the negative that it's not something that clearly they've done that it's nothing to do with the business.
Great. Like, someone's pointing at the back. Is there we got any questions? No? Okay. Right, well, last chance. Around. We'll bring it to a close. I thank you very much to everybody that's attended. I appreciate that this time of year it's a bit of a jarring move to get back from beaches, holidays. I know you've got Auckland anniversary coming up, so probably focus on that, and to start thinking about our work. So we really do appreciate you taking the time. I'd also like to thank the staff that have been involved behind the scenes. It's been an eye-opener for me as to how much technical work goes into all those webinars. So I will send emails after conferences to more people no doubt throughout the year. Last thing to note is the 10th of February, that is 5 PM 10th of February, that's the date the submissions are due. If you have any queries before then, please feel free to get in touch with the Commission, get in touch with me or Grant if you need to. And frankly, if you have any questions you wanted to fire to Charlotte, we could probably find a way of making that happen. So thank you all, and thank you Charlotte in particular for coming. We really do appreciate your time, including the time getting it all set up.
Thank you.
You're welcome.
Thanks.